Federal law is not always supreme, not even close. Anyone telling you that is telling you a big, fat lie, and one that's ripped from the British system that sparked the American Revolution. So on this episode, I'm going to break down the big Supremacy Clause hoax. It's one of the worst distortions of the Constitution, and hopefully someday more people will understand this, so we the people can stop embracing the very system that the founders and the old revolutionaries fought a long, bloody war to free themselves from. But first of all, before getting to that, welcome, and thank you for joining me here on the path to liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Friday, March 14th, 2025. Let's kick it off here with an article from Mike Meharry, and he repeats that same message. It's a very important one because we have to understand that the old revolutionaries risked their lives to reject a certain type of system. And I think it's a total shame, a disgrace, to dishonor them by embracing the system they fought so hard to get away from. Anyways, the American colonists fought a long, bloody war to free themselves from a tyrannical government, only to see the people eventually embrace the very system they struggled to throw off. That may seem like a stinging indictment, wrote Mike, but a careful examination of the U.S. system of government today, I would say that how it is playing out in practice, how most people treat it or think they understand it, not how it's supposed to be, but it reveals that it rests on essentially the same philosophical foundation as the 18th century British system that Americans rejected. And a big part of what they were rejecting was a total conflict between the colonists and Great Britain on the understanding of sovereignty, who held final authority. That was a big part of it. And Mike says that in the British system, the people were not sovereign. Parliament was, the king and Parliament in essence. He said the government itself enjoyed supremacy. And as historian Gordon S. Wood put it in The Creation of the American Republic, if you want a book recommendation, there's a good one. Any limits on Parliament were strictly theoretical. Even moral and natural law restrictions, constitutional and legal limits only bound lawmakers as far as lawmakers were willing to be bound. In other words, government determined how far government was going to go, maybe for practical reasons or political reasons, but there was no restraint on their power, really, when you got down to it. And nowhere was that more apparent, at least to the old revolutionaries. We don't learn about it much today, but I'm doing my best here. The 10th Amendment Center as a whole, we're doing our best to teach people about this. But nowhere was that more apparent than in the Declaratory Act of 1766, which literally claimed power over the colonies and the people in, quote, all cases whatsoever. Thomas Paine said even the notion of this is impious because such an unlimited power can only belong to God. Basically, all the leading revolutionaries, whether it was Hancock and Paine or Samuel Adams, Thomas Jefferson, John Dickinson, and the like, they all understood this claim to unlimited power in all cases whatsoever, centralized authority over everything, was the root cause of everything else they faced: taxes, standing armies, etc. And this is what led to their independence. And I covered that in much more detail in an episode just this week, The Forgotten Law That Caused the American Revolution. It'll be in the show notes, blog post for this episode. Make sure you do check that one out if you haven't yet. Now, unfortunately, despite the fact that the founders, the old revolutionaries, fought this war to secede from a system of unlimited centralized power, the way that most people treat the Constitution today, and specifically the Supremacy Clause of the Constitution, is really no different than the Declaratory Act. They have power in all cases whatsoever, and they determine if they went beyond the limits of what they should do. Basically, federal law for these people today, federal law is always supreme. Federal law always overrides state law in every situation, basically, unless the federal government decides that it made a mistake. And that really is the British system. And there are many examples of this. Let me pull one up here in showing how almost everyone, all the experts especially, get this wrong. The legal experts, the lawyers, But so do most people who talk about it. Here, for example, from State Court Report, which is part of the Brennan Center or a project of the Brennan Center, they point out that grounded in the Supremacy Clause of the U.S. Constitution, federal preemption stands for the principle that federal law supersedes conflicting state law. End of story. No caveat to that. But anytime there's a conflict between federal and state law, we're basically told all across the political spectrum, federal law always supersedes. Federal law always overrides the states. Here from Cornell Law, maybe not as bad as what we just read there from State Court Report. They say, in general, federal law takes precedence over any conflicting state law. It's not saying once in a while, but kind of as a rule of thumb. So most of the time, you don't even have to think about it. It's always going to be federal law is supreme. And here they take it a little further. They say traditionally, when it is not indicated, federal law does not preempt state law in areas traditionally regulated by states, unless, this is the only caveat they want to tell us, sometimes state law is okay if it conflicts with the feds because they've traditionally held this regulatory power. But here's the caveat, unless Congress's intent to preempt is clear. So they're basically saying that federal law is supreme as long as Congress says so. Nothing to do with the Constitution, just as long as the federal government says federal law is supreme, end of story. And this one from Mark Pulliam, writing for the Tennessee Star. This here is possibly the most clear and possibly the most disgraceful example of openly supporting the view of governmental supremacy, the system of the British, total opposite of the Constitution. Here's what Mark has to say. We have a Constitution that has a supremacy clause that says federal law is supreme over state law. Well, only if you haven't read the Constitution does it say that, because that's just cutting out some of the words to lie about it. And that's been the law, he said. It's been in the Constitution since it was ratified. So Mark Pulliam over at the Tennessee Star is telling us that the Constitution tells us that federal law is supreme over state law. Period. End of story. No caveat, no nothing. We're going to read the text of the Constitution to show that he's lying here. And then on top of it, he takes it even further. He says we have to have a system where if the federal government makes a rule, it's the rule. So if they pass something, everyone's got to get in line. No limits of the Constitution. They can just do whatever, basically. Now, maybe he wouldn't argue that they are really empowered to do whatever, but he argues here that they're empowered to determine if they violated their own rules, the rules given to them by the people of the several states. He said it's binding on the states. So whenever they make a rule, it's the rule, and it's binding on everyone until the federal government determines it made a mistake. This literally is a replica, almost exactly, of how the British system operated under the Declaratory Act of 1766 and the view of governmental supremacy where Parliament held sovereignty. It wasn't an agent of the people as the founders set up under the Constitution. So we have to have a system where if the federal government makes a rule, it's the rule. I got to keep repeating that because it's nuts. It's binding on the states unless and until a state goes to court and gets somebody to determine that it's not a valid action. Sometimes these things take time. I mean, this is more of a big government view than the biggest big government guy at the time of the founding, Alexander Hamilton. We're going to get a little bit to him in just a little bit. But so Pulliam is making the case that federal law is supreme the moment they pass it. It's always constitutional until the federal government decides, oh, sorry, we made a mistake. Maybe that was unconstitutional, or this is a bad policy. So how about we read the text of the Supremacy Clause in Article 6 of the Constitution? This Constitution and the laws of the United States, which shall be made in pursuance thereof. I'm really emphasizing this because if you can compare this with what Mark and others tell us, that federal law is supreme, laws of the United States are supreme, and conflicting state laws have to go. They always skip over which shall be made in pursuance thereof. I mean, it's as if the founders put it in there. It's just superfluous. It shouldn't have existed. I mean, it just needs to be ignored. Well, it only needs to be ignored if you want to lie to the people and tell them that federal laws always supreme. But no, the big caveat is that it's supreme when made in pursuance of the delegated powers of the Constitution. And again, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. It's really actually pretty simple and straightforward stuff, this Supremacy Clause. Federal law is only supreme when it's passed within the limits of the delegated powers of the Constitution. And they're not many. There's depending on how you count them, a lot of people say there's 17 powers in Article 1, Section 8, or 18, depending on how you count those. But really, throughout the document, there's about 30 to 35 powers that have been delegated to the federal government, and everything else is reserved to the states or the people, respectively. And so that's really what the Supremacy Clause is telling us. The Supremacy Clause does not say this Constitution and any old act that Congress decides to pass and the president decides to sign is the supreme law of the land. It says in pursuance thereof. Here's how St. George Tucker described it in view of the Constitution of the United States. He said that a law limited to such objects as may be authorized by the Constitution would, under the true construction of this clause, be the supreme law of the land. But a law not limited to those objects or not made pursuant to the Constitution would not be the supreme law of the land, but an act of usurpation and consequently void. An act contrary to the Constitution is void from the moment they pass it, despite the fact that people like Mark Pulliam and other legal experts that are trying to scam you want you to believe that federal laws or federal rules are valid and binding until the federal government determines that they're not. That view has nothing to do with the system of the founders. And Mike says that this was not some novel interpretation from St. George Tucker. He said this was how supporters of the Constitution repeatedly explained the Supremacy Clause during the ratification debates. I've got a couple of examples for you. Mike says even Alexander Hamilton conceded that any federal act outside of its constitutionally delegated powers would be void. Here from Federalist number 78. Hamilton really hammers this home. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. It's not valid until they decide that it's void. It's void the moment they pass it. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this, like our legal experts in this episode, the villains of this story, to deny this, Hamilton writes, would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. The view that all federal rules are valid and binding on the states until the federal government decides that it made a mistake is taking the position that they can do not only what the powers do not authorize in the Constitution, as Hamilton pointed out, but also what they forbid. James Iredell, one of the first associate justices of the Supreme Court, put it like this during the North Carolina ratification debates. He said, when the Congress passes a law consistent with the Constitution, it is to be binding on the people. If Congress, however, under pretense of executing one power, should in fact usurp another, they will violate the Constitution. I presume, therefore, that this explanation, which appears to me the plainest in the world, will be entirely satisfactory to the committee. And Hamilton tells us a little bit more in Federalist number 33, pretty hardcore about this, because if they're usurping power, St. George Tucker described usurpation as treason against the sovereignty of the people, because in the American system, the people of the several states hold sovereignty, final authority, and government is really just merely their agent doing those things that the people of the several states decided they wanted it to do through the Constitution. Here's Hamilton discussing supremacy in Federalist number 33. He said, "But it will not follow from this doctrine that acts of the large society which are not pursuant to its constitutional powers, but which are invasions of the residuary authorities of the smaller societies, will become the supreme law of the land. These will be merely acts of usurpation and will deserve to be treated as such." So the legal expert's view is that soon as the federal government gives you a rule, it's in fact valid and binding, which means it is the supreme law of the land. So totally contrary to even what Alexander Hamilton had to say in Federalist number 33. Now, of course, some people will say, well, only the federal courts can decide if the federal government went beyond the limits of the Constitution. But Thomas Jefferson really shredded that in his Kentucky Resolutions of 1798. He explained that relying on government to determine the extent of its own powers means the government is supreme. Again, that's the British system. The government holds final authority. The Constitution is not supreme in that scenario, even though the Constitution itself says the Constitution is supreme. Here's how Jefferson put it. The government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion, and not the Constitution, the measure of its powers. You know, I think if it's between Mark Pulliam or Cornell Law School and the author of the Declaration of Independence, even though the latter might make some mistakes from time to time, to me, that's a no-brainer on who I'm going with on that one. Now, back to Mark, though. Again, government supremacy really is the very definition of tyranny to the founding generation, to the old revolutionaries. That's what they fought a war to free themselves from. And that's exactly what our friend Mark wants you to believe that the Constitution created. Either he's ignorant or he's hoping that his readers are. I'm not sure which one it is. Maybe it's a combination. But he said the way to solve conflicts between states and federal laws that states disagree with is you get your attorney general, and we have a very capable one, Jonathan Scrimetti, to go to court and challenge these things. Again, he's just doubling down on the idea that the only way you deal with conflicts between the federal government and the states to determine if the federal government violated the Constitution is to ask the federal government if it thinks it violated the rules given to it, making its discretion and not the Constitution the measure of its powers. And then just to reiterate what he said before, we have to have a system where if the federal government makes a rule, it's the rule. It's binding on the states unless and until a state goes to court and gets someone to determine that it's not a valid action. Sometimes these things take time. So again, he's saying that the limits of the Constitution are what the federal government tells us the limits of the Constitution are until we can get the federal government to somehow change its mind. And I'll tell you what, that has not worked out very well unless you support the largest government in the history of the world. Mike Meharry absolutely nailed it with this. He said, for all practical purposes, the federal government today, especially with people espousing this kind of view, teaching it in law schools, acting as experts, it operates without any limits at all. Everything the federal government does and approves is considered constitutional until the federal government changes its mind. Even though, Mike writes, the founders committed the U.S. Constitution to parchment, judges, politicians, and academics and lawyers, they've morphed the meaning of words, or they've ignored some like in pursuance thereof, and they've changed the character of the supreme law of the land into something that the founders and ratifiers would scarcely recognize. And Mike really laments this part. He says, we have become what our forefathers sought to destroy. Here's a little bonus from James Madison writing in Federalist number 45. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. And again, because there's only around 30 to 35 powers that the people of the several states, in their highest sovereign capacity, as James Madison later described it, delegated to the federal government, their agent, that means that the federal government isn't actually authorized to do all that much. Almost everything is reserved to the people of the several states. And Madison put it like this: the powers reserved to the several states will extend to all the objects which in the ordinary course of affairs concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. So with that in mind, the notion that federal law is always supreme actually gets it almost completely backwards. If you're looking for accuracy, or at least trying to be as close to accurate as possible, you'd be far closer if you actually said state law is always supreme. The Supremacy Clause. People almost always get this backwards. It does not say anywhere that federal law is always supreme, end of story. It has a really important caveat. It says that federal law is supreme only when made in pursuance of the delegated powers of the Constitution. And actually, it tells us two key things. It exists for two essential purposes. First of all, to affirm the supremacy of the Constitution, not the supremacy of the government, not the supremacy of whatever federal act they decide to pass, and not the supremacy of any opinions of anyone in the federal government in any branch. And two, it exists to draw a clear line around the limits of federal power in the Constitution. And then on top of it, maybe more importantly, if we're considering fundamental principles of both the American Revolution and the foundation of the Constitution, the people of the several states are the source of all power. They hold sovereignty, final authority, and government exists merely as their agent. So a government that gets to determine the extent of its own powers actually has no place in the American system because it is the very definition of tyranny. Wait, I got one more bonus for you. Let me see if I can pull this up here. This is from one of the most prominent anti-federalist writers, Sentinel, writing in December of 1787, a little warning about the Supremacy Clause. He said the words, "pursuant to the Constitution," will be no restriction to the authority of Congress. Man, he absolutely nailed it. We think it's Samuel Bryan, not 100% sure on this one, but again, the words "pursuant to the Constitution" will be no restriction to the authority of Congress. He was recognizing in practice that really ultimately words on paper do not enforce themselves. They never did, and they never will. If you count on that, you shouldn't be surprised when government people find all kinds of ways to expand their power. I covered how we're supposed to enforce the Constitution rather than waiting on the Constitution to enforce itself in an episode, the most popular one we've done, how to enforce the Constitution, whether the government likes it or not. That'll be linked to in the show notes over at 10thamendmentcenter.com/path to liberty. And to be honest, on this thing, we are really fighting an uphill battle here because the school system today, from day one through all the law schools and all the political pundits and the so-called experts, they teach a very dangerous myth about unlimited federal supremacy. And that's part of why we work so hard every single day here at the 10th Amendment Center to reach and teach more and more people with the truth from the founders themselves about these absolutely crucial foundational principles. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that dirty government fiat that they are quickly and deeply devaluing, please consider throwing it our way over at 10thamendmentcenter.com/members. Our membership program starts out at just $2 a month, and we punch way above our weight class here at the TAC. We also have annual, 5-year, and lifetime options. Or if you prefer to make a one-time contribution, let's say you don't want to join as a member, that's cool. Or you already are one and you want to help us out some more, that's also pretty awesome. You can do that over at 10thamendmentcenter.com/donate. No pressure. We're going to continue doing what we do every day. We've got thousands and thousands of articles and blogs and podcasts and videos that we put out for free. We'll continue doing that, but we do need your support to be able to continue to reach more people, to expand our work, and, well, to teach the truth. So again, 10thamendmentcenter.com/members, 10thamendmentcenter.com/donate. I'd be extremely grateful for any consideration you can give to putting our financial faith behind our work. You can also help us spread the word by hitting that like button, reviews on Apple Podcasts, any other podcast platform, comments in the archive video or Spotify, wherever. Subscribe, get notifications. Watch time is a big one, especially on YouTube. The greater percentage, like, I don't know, 90% is great, but 130% is really great for that algorithm over on YouTube. Basically interact with whatever platform you watch or listen on as much as possible, and that will tell the algo to show us to more people. And we've been reaching more people than I ever thought possible, but we're still scratching the surface. I'm so grateful for your help. I'm grateful for you spending some of your time with me today. I hope you enjoyed this episode. I hope it made you think. I hope you learned something. That's more important than anything. I hope you have an awesome weekend, and I look forward to seeing you next week here on the Path to Liberty.